future-proofing your business against future disputes. With the electronic age, electronic records are really useful to us as lawyers later on if you have a dispute. And so any personal messages, emails, all those kind of electronic records can be really useful further down the track. And so we are finding it quite frustrating sometimes when a dispute turns on something that might have happened ages ago. I've got one at the moment. Actually, my business partner's dealing with it. It was to do with a business relationship that started back in 2006. And our client's not sure if he's kept all of those records. Now, the records that I'm talking about is if you have a business collaboration with somebody, or somebody selling your product, or things like that. These days, electronic storage is so cheap. I recommend keep all your records. Keep all your records, because you never know what's going to be valuable later down the track. Another thing that sometimes happens is when people get into a dispute, often if it goes onto social media, people will, there'll be a flurry of personal messages exchanged, and a natural reaction is to unfriend the other person because you just think, whoa, this has got too heavy, I don't want to deal with it. Before you unfriend that person, please screenshot any messages, especially any threats, anything unpleasant, in fact, anything, because you don't really know what will be important to a lawyer later on if there is a dispute. And the reason why records are so important, one reason is that it helps you to win a case if something goes to court, but more important is it can actually help you avoid litigation. So we've got a case on at the moment where our client had worked together with another person. She was licensee of the main company, and now later, 10 years down the track, there is a trademark dispute. Our client has selected a trademark which is different from her former licensor, but the former licensor is saying, well, actually, no, that name is something we've used for years in our business. Our client says, I can remember about 6 years ago getting an email from this licensor to say some of the licensees had been using this name as a nickname for the business, but the licensor did not want that name to be used. And so it was an instruction from the licensor to the licensee saying, don't use that nickname. That's not our business name. And now so they didn't use the nickname, but now our client wants to pick up that nickname and use it in her business. And so if she can find that email from 6 years ago, that will be really helpful. If she can't, it's going to be problematic. There was another situation where I had with a client who experienced business bullies. Somebody was making very personal and degrading threats against my client on social media. This was all in a personal message. Unfortunately, my client didn't screenshot it. So now when we're trying to take the other side to task, it's very difficult because we don't actually have a record of those messages. We know they existed. We don't have them. In another case, my client had a social media page, a Facebook page. One of the people who did, he was like a marketing guy. The marketing guy was an admin on the page. The marketing guy has now taken over my client's business identity, kicked my client off the page, and now the marketing guy is doing anything they want on the page. Now, this is a bit of a success story because before he kicked my guy off the page, this marketing guy started making allegations and saying any messages that you get from my client who actually owned the business are not official from the business. So basically the marketing guy was saying, if you get messages from me, they are official. If you get messages from this other guy who actually owns the business, he's a scammer. But luckily in that case, our guy knew somebody who was still on that business page when these messages were put up, and managed to get a screenshot that way. But now our guy has been removed as admin from that page. He doesn't have access. He's been blocked from it. And his friend who was on that page has also been blocked from it. And so it's very difficult now to get any future proof of wrongdoing. So keep all of your records. If you're creating a new product, a new system, a new course, keep all of your, I want to say prototypes. So if it's a product, it would be a prototype. But your drafts, keep your drafts, your old versions of your course, because later on, if there's a dispute, those drafts might be the thing that saves you from a copyright infringement case, or might prove that you own the copyright if somebody else is infringing. So in the olden days, the rule used to be, and the legal rule is, keep your records for 7 years. But when it comes to disputes, you might need to go back 10 years, 20 years. Keep everything. Electronic storage is so, so cheap. It is worth keeping it. If it's going to keep you out of court, it's going to save you perhaps the costs of a litigation case, which could be $100,000. So to future-proof your business, keep electronic records as complete as you can, including all those emails that you might not think are of any consequence.